Thank you, everybody, for having me here this afternoon. I've been asked to talk to you about the legal process surrounding a foster child when they come into the system and how that works with DCS. I was told I have to give a brief bio. So my brief bio is I had many varied careers in my life, and when I was in my 40s, I lost my mind and went to law school. And I graduated from the University of Arizona School of Law in 2004. And I went to work for the Arizona Attorney General's office in Pima County. And I was a trial attorney and then an appellate attorney representing the Department of Child Safety when they removed children from their parents. In 2008, I moved to Yavapai County and I became a unit chief for the Attorney General's office, meaning that I supervised the attorneys in the 7 northern counties. I was in charge of all the trial attorneys that were running around representing DCS in 7 counties. In 2011, I took a great leap and went into private practice and went from representing DCS and basically prosecuting to defending parents whose children had been removed from them and representing kids and advocating for kids who are in the foster care system. And then, like Sue said, it's been a little over a year ago, I took a little hiatus from practicing law and became a CASA coordinator in Yavapai County. When I was practicing law, I had CASAs on cases. I always got along great with the CASAs, thought they were a real asset to the case. But until I became a coordinator, I had no idea what is involved in becoming a CASA, the certification process, the time that you spend in the field with the kids, in court advocating. It is a real commitment. I don't think there's any other volunteer position like it. And I just have to say that the CASAs that I work with in Yavapai County are all just extraordinary people, and I thank you all for wanting to be a part of this. And I think if you decide to go forward and jump in and take a case, you're going to find it to be very, sometimes frustrating, but very rewarding work. And most important, you'll see that you will make a huge difference for these kids. There's a big difference in a case with a CASA on it and a case that doesn't have a CASA. So that's a little bit about me. Before I jump into Dependency 101, I know Jenny touched on it a little bit, but CASAs often ask if you guys are mandatory reporters. The law says that a report must be made when an individual develops a reasonable belief or suspicion that a child has been abused, neglected, exploited, or abandoned. So a reasonable belief. You don't have to prove it up. You just have to have a reasonable belief. And I know Jenny gave you a list of who the mandatory reporters are, including people like a physician, a physician's assistant, doctors, social workers, psychologists. There is a list, but the way the law is written, that is not an exclusive or wholly inclusive list. It's not limited to those people that are listed. So my argument would be that if you suspect child abuse or neglect, you are a reporter. And so you need to call the DCS hotline. It's anonymous, if you want it to be. If something comes of it, it's filed in the dependency court. Even if you did give your name, you are protected as a source. Your name can't be released. So if you're out with your CASA kid and you think something's up, the first thing you're going to do is call your coordinator, call the DCS case manager on the case because this kiddo's already in the system. But if you suspect child abuse that's going on that hasn't been reported, you do need to call the hotline. And I remember in the old days, if you called the hotline, you could wait a couple of hours to talk to somebody, and now I'm told it's less than a minute that you will be hooked in with somebody to give you a report. So before today, or before you decided to become a CASA, and I know some of you were CASAs in other places, how many of you have heard of dependency law? Oh, that's a lot for a group, okay. Dependency law is a very obscure, different animal. It's not rocket science. It's an attorney that does a lot of social work. When I was working for a law firm in Tucson, a big law firm in a really nice building, and I thought, I'm going to go to law school and I'm going to be a trust and estates lawyer or a bankruptcy lawyer. I never thought I'd be a juvenile lawyer. I didn't know anything about juvenile law. I went to law school. They don't teach juvenile law. They don't teach dependency law. You can take family law, and there's some overlap, but there's no dependency law course. But I met this woman who was a dependency lawyer in Pima County representing children, and she wanted somebody to help in her office with her phone calls, with going out in the field and meeting kids. So I applied for the job, and the next thing I knew, I was in this beat-up Toyota Corolla in a wash south of Tucson in Ajo, looking for a family living in a trailer out in the middle of the desert because there had been a report on the kids. And that was my great entry into dependency law, and you've heard I've been in it 13 years now. And I've done it from the prosecution side, I've done it from the defense side, and now I'm doing it from the CASA perspective, and so I think I've had a really good view of what goes on. Dependency law is governed by Title 8 of the Arizona Revised Statutes, the Rules of Procedure for the Juvenile Court, and appellate case law. There are two divisions of the Court of Appeals, one in Phoenix, one in Tucson, and then of course we have the Arizona Supreme Court. Juvenile law trumps all other law except for the Court of Appeals and the Supreme Court. So say an attorney has a trial set in the family court, and now she's in the juvenile court and that judge wants to set a trial, you've got to dump your family case and appear on your juvenile case. Even the Court of Appeals hears the juvenile cases, reviews the juvenile cases before any other case. So it trumps everything. So I know that it's been referred to as playpen law. I know that it's been used to punish judges. If you were a bad judge, you got rotated to the juvenile bench. I would beg to differ with that assessment. I mean, I think it's very important. It involves constitutional rights of the parents, their right to parent their children, and like I said, it trumps every other area of the law. So we do have the statutes and the case law that governs our law in Arizona. You'll see different things happening in courtrooms depending on the counties you're in. I know Sue gave you a sheet that kind of shows that there are different timelines. Legally, the timelines are all the same, but the judge might hear the cases more frequently. It depends on the county that you're in, but just know that obviously we are governed by the state law. What is a dependency? Well, a dependency can involve abandonment, which is the failure to provide reasonable support and to maintain regular contact with the child, and the bright line is 6 months. Abuse, which can be physical, emotional, or sexual. Neglect, which is the inability or unwillingness to provide supervision, food, clothing, shelter, or medical care. Neglect is not poverty. If you have a family living in a yurt out in the desert or even living in their car, if the kids are cared for, they're cared for medically, they're getting their educational needs met, that's not a dependency. Even if we think they would be in a nice foster home would be a better thing for them. As long as they're safe and cared for, it's not a dependency. But usually when we find a family that's living in a car and in poor conditions, there's usually something else going on, like substance abuse or mental illness, and so then we do get involved in the dependency process. Facts related to a child's exposure to drugs and drug environments. Obviously, children that are living in a house that's manufacturing methamphetamines, or I had a case that they were living in the car and they had a meth lab in the trunk. They were like a little mobile meth lab going on. Even prenatal exposure. Obviously, we can't file a dependency petition on a baby that hasn't been born yet, but if mom is exposing the baby in utero and then the baby is born positive for illegal substances, that could be a dependency. Definition for a dependent child. A dependent child is a child who is in need of a parent, they only need one, who is willing and able to safely and effectively parent the child. Most of our parents are very willing to parent their children, but for whatever reason, they're unable. 99% of our cases start off under this catch-all definition. It can also include a parent who is unable because of the child's behaviors, like an incorrigible child. We see this a lot. They start out in the juvenile delinquency system, and the parents say, we can't take Tommy home because we can't manage his behaviors. A dependency could be filed and could end up in the system that way. More definitions of dependent children: destitute or not provided with the necessities of life. A home is unfit by reason of abuse, neglect, cruelty, or depravity. A child under the age of 8 years and found to have committed an act that would result in adjudication as a delinquent juvenile. I had a case in Apache County where an 8-year-old boy murdered his father and his father's best friend. And I was working for the Attorney General's office at that time, and we went swooping up there because we figured this kid is not, he just killed his father. He's not going to have a parent who's willing and able to protect. And unbelievably to me, still to this day, his mother came and dealt with the criminal case and got custody of him. One of the exceptions is the use of Christian Science treatment or a parent's refusal to administer psychiatric medications. One of those things on its own is not enough to find abuse, neglect, or a dependency. Christian Science parents do have the right to refuse treatment, and parents do have the right to refuse psychiatric medications. I've only seen this once. It was in Yavapai County. DCS filed a petition because the kiddo had leukemia and the parents were Christian Science and they were refusing treatment. And I thought, man, I am so glad I'm not that judge, because how is she going to decide this? And at the last minute, the parents decided to go through with the treatment. So you don't see that very often, but that is an exception. So when you talk about dependency cases, when we talk about it as CASAs, we're talking about the juvenile court. And your cases will all involve DCS. And DCS, gets a call from the hotline and they go out to investigate. I'm sure Jenny explained all of that to you. But dependency issues can come up in a lot of other settings. In the probate court, there is such a thing as a Title 14 guardianship, where the parents can say, okay, we can't parent right now, and so we're going to give the kids to grandpa and grandma, and we're going to do a Title 14 guardianship and let them parent them. Our parental rights are intact, everything's intact. We file this in the probate court. The judge grants it. The problem with the Title 14 guardianship is the parents could decide, I want the kids back, and that they can't parent. They can go revoke that guardianship at any time. There's a guardianship in the juvenile court that you cannot just revoke like that, and we'll talk about that a little bit later. But so it can come up in the probate court where we have an unfit parent. In the adult criminal court, say the judge finds out that mom and dad are both incarcerated. Okay, where are the kids? The delinquency court, like I talked about with the juvenile in the delinquency system, that juvenile's guardian ad litem in the delinquency system might decide, wow, I don't think mom and dad can parent this child because of the child's behaviors or because I know mom and dad are using drugs. Or in the family law setting where you have a custody battle and it starts becoming clear that one or both parents have something going on where you don't have a fit parent, you only need one. And so the whole idea of dependency comes up there. In any of those settings, that judge can order DCS to do an investigation. So DCS will go in, say, on a family law case, and they do an investigation of the parents and of the children, and then they generate a report to the court. If DCS decides during that investigation, no, this is just a custody battle, the parents are just being, stupid with each other, we're not going to file anything, and they go report that to the judge. Or DCS might investigate and say, yeah, there's a problem here with both parents. They can file in the dependency court, and once they do that, everything in the family court is put on hold because the juvenile court trumps. I saw an interesting case 2 weeks ago in Yavapai where a 16-year-old filed to be emancipated from his parents. And he wrote a letter to the judge with his petition, and he came into court and testified about what was going on in the family home. And at the end, the court, after the judge read the petition, she ordered DCS to investigate, and then she set a hearing on the petition. The 16-year-old came in with his mom and dad and witnesses. We had a little evidentiary hearing, and at the end of it, the judge ordered DCS to remove the children and to file the dependency petition. And obviously she denied the emancipation, but that was yet another way that the dependency court can get involved. A petition is asking the court to do something. Like the slide says, it's a written statement of the facts that allege delinquency, incorrigibility, or dependency. In most of our cases, it'll be a dependency. Once in a while, you'll get, like I said, the incorrigible child. I don't see causes on too many of those. So most of the time, it'll be allegations of dependency. The petition has to be filed with the juvenile court within 72 hours of removal. So Jenny probably told you guys about serving a temporary custody notice to the parents. So DCS does their investigation. They decide we're going to have to remove these kids. They serve a TCN, temporary custody notice. Within 72 hours of serving that notice, they have to file a petition in the juvenile court. So it's funny because when you're a CASA, it seems like these cases go on and on, like how much more time are we going to give these parents? When the reality is, compared to other areas of the law, the timelines are really pretty fast because we don't want the kids hanging out in limbo. So at the very beginning, you've got 72 hours to file your dependency petition. Legally, if you don't file it, you have to return the kids. And a few years ago in Maricopa County, DCS filed a bunch of, I think, 5 petitions late. And they were all in front of one judge, and he dismissed all of them, saying you weren't within the 72 hours. Well, in one of the cases, both of the parents were incarcerated, so who were we supposed to return the kids to? And so DCS took that up to the Court of Appeals, and the Court of Appeals said, no, the bright line rule is 72 hours, but you have to look at substance over form, and you always look at the best interest of the child. That's paramount in the juvenile court. And so DCS was just ordered to refile, to serve another temporary custody notice and file within 72 hours of that notice. There is such thing as an in-home dependency, where in a regular dependency where the children are removed, the children are now in the legal custody of the state and the physical custody of DCS. In an in-home dependency, they leave the kids in home with the parents, so the parents still have physical custody, but DCS and the state has legal custody. We see those once in a while where they try to salvage. Truthfully, most of the time they end up removing the kids anyway. But in your cases, your case will, if the case is going along and the parents are doing what they're supposed to do, it can become an in-home dependency. You know, the kids are out of home, the parents work services. The judge doesn't just return the kids and dismiss the case. The judge returns the kids to the physical custody of the parents and still has DCS legal oversight for usually 3 months at least. So the petitions that you'll see are all filed by the Arizona Attorney General's office because that's who represents DCS when they remove kids. But the statute says that any interested person can file a dependency petition. So grandparents, relatives, a guardian ad litem on a delinquency case, and I'll talk a little bit about attorneys and guardians ad litem in a minute. Any party who has an interest in the welfare of the child can file a dependency petition. Who is involved in a dependency case? Dependency cases are the most lawyer-ridden cases you'll ever see because when children are removed, the parents are appointed counsel. If you have a mom, even if she's married to dad, and say she has kids with 2 other dads, all 4 of them are going to get attorneys. The kids on the case are either going to get an attorney or a guardian ad litem or sometimes both. So right there you've got 5 attorneys, plus you have the attorney for DCS. So you have all the attorneys involved, Parents Council and the Attorney General's office. DCS is involved. CASA hopefully is involved. The Foster Care Review Board, I don't know if anybody's talked to you about that, but that's a panel of usually 4 to 6 people from the community, and they review the DCS cases every 6 months for every kid who's in out-of-home placement. They report to the court, so they're involved. The placements, even though a placement is not technically a party to the case, they're obviously a big part of the case, and sometimes tribes are involved. The difference between the children's attorneys and the guardians ad litem, it's different county by county, and I know Sue was putting together that sheet for you guys, and that was one of the things she was going to look at. But the difference is, an attorney appointed to represent a child has an attorney-client relationship with the child, just like an adult does, just like the parent does. It's a privileged, confidential relationship, and that attorney advocates for what the child wants. So usually, it's older children that are appointed attorneys because they can say what they want. the children can say what they want, and the lawyer's job is to advocate that position to the court. A guardian ad litem is in Arizona also an attorney, but if you're guardian ad litem for a child, you don't have the attorney-client relationship. There's no privileged relationship. You get to tell the judge what you think is in the best interest of the child. So especially if you have really young children or babies that can't advocate for themselves, they're most likely going to get a guardian ad litem who's going to advocate what that person thinks is in the child's best interest, which isn't always aligned with what the child thinks. So sometimes you can have an older child, they're appointed an attorney, and the attorney will be, oh, okay, I'll advocate that position, but I don't think that's in your best interest. So I'm going to ask the judge for a guardian ad litem. So now the child has an attorney and a guardian ad litem, and they may or may not be on the same page. So it is a free-for-all. In Yavapai County, we just have this long table in the courtroom, and everybody just lines up down the table, and the judge just goes down and ends with the CASA. The Preliminary Protective Conference, the PP5 and the PPC. So the petition is filed within 72 hours. And once it's filed, the juvenile court has to file a PPC and a PP5 within 5 to 7 business days. Again, we got the clock ticking. These kids are in out-of-home care. Parents don't have their kids. They've got a right to due process. And so these hearings are set. And they're they are in two parts. First, you have the Preliminary Protective Conference. In that conference, all of the people I just told you about will be there. DCS will be there with their attorney. Parents will be there with their attorneys. A lot of times it's the first time they've met their attorney. Sometimes the kids are there, sometimes not, but definitely somebody representing the kids will be there. Usually a mental health specialist will be there because they've assessed the kids. And there's no judge. There's just a facilitator, and Yavapai County CASA coordinators facilitate the conferences. And in those conferences, you talk about 3 things. You talk about placement. Where are the children placed? DCS, are you leaving the kids there? Mom, do you agree or disagree? Dad, what's your position? What's the kid's attorney's position? Talk about placement, who agrees or disagrees. You talk about visitation. Okay, what is visitation going to look like for the kids and the parents? Usually, almost always, the visitation starts out supervised by a DCS-approved supervisor. So say DCS will say, kind of their standard is, we're going to offer mom and dad 2 hours a week, 2 times a week, supervised. And then as the case progresses, hopefully they'll get bored and we'll get unsupervised, but it starts out supervised. Everybody gives their position on the proposed visitation schedule. And then we talk about services. What services is DCS going to provide for the kids, most importantly? And then what services, Mom, are we asking you to do to get your kids back, and Dad to get your kids back? And everybody discusses that, and then do you have agreement or disagreement on services? Yes?
Where in this process is a CASA assigned?
Usually, it's pretty rare for a CASA to be in on the preliminary protective hearing. Yeah, it's usually after the dependency has been found. Remind me, and I'll tell you later in the process where usually a CASA jumps in.
Okay, thank you.
We try to appoint them close to the beginning of a case so that you're with the kids throughout the life of the case. And once in a while, like I had a CASA on a case and a new baby was born. And so we had to have a preliminary protective hearing on the baby. And she was already CASA for the older kids, so she came to that hearing, which is great because then she's really in at the beginning. But generally the CASAs aren't at the PP5. So once we come to all of our agreements and disagreements on placement, visitation, and services, we go before the judge. And we tell the judge, this is what we agreed on, this is what we disagree on, and the judge decides, okay, this is what placement is going to be, this is what visitation is going to look like. These are the services that I'm ordering DCS to provide, and these are the services that I'm ordering Mom and Dad to participate in. So you leave that PP5 hearing with a 10 or 12 page order of everything that happened, from service to appointment of counsel, future hearings, all of the services, everything that's been ordered, they leave with a copy of that. It's 5 to 7 days after serving, after the petition is filed. The PPC is held right before the PP5. They're the same thing. You just meet before you go in before the judge to see how many agreements you can come to without the judge. So in the preliminary protective hearing, you'll tell the judge about what you've agreed on, what you haven't made agreements on. The other piece is the parents have to tell the judge through counsel how they're going to plead to the petition. So the petition will have allegations against the mom and the dad. For example, they'll say mom is unable to parent or, because she has a substance abuse issue, and then some facts to support that. Mom is unable to parent because she's engaged in domestic violence with dad, and some facts to, okay? So allegations for each of the parties. And you have to tell the judge how you're going to plead to that. Now, dependency cases are civil cases. They're not criminal. Even though a lot of times what causes the kids to come into care can definitely be prosecuted criminally, DCS and filing a petition in the juvenile court is not a criminal case. It's really frustrating to us sometimes because you'll think, how could these people not be being prosecuted? I had a case in Yavapai County where these people adopted 10 children and they were caging them. And DCS removed them, and we ended up in court, and I ended up representing all the younger kids. And I called the county attorney and said, are you going to prosecute for child abuse and child endangerment? And they said no. And they have a higher burden of proof, which I'll explain in a second, but they have a way higher burden of proof than you do in the dependency court. So sometimes I think they don't believe they can make that burden of proof, and so they don't file on it. And sometimes, truthfully, I think they think DCS has the kids are safe, we're going to let this go. So we're civil, we're not criminal. And that means that in a criminal case, and I'm not talking down to you, I don't know how much anybody knows about law, but you know, you always hear about the state has to prove their allegations beyond a reasonable doubt. That's criminal. That's a hard burden of proof for the state to prove beyond a reasonable doubt. Below that burden of proof is clear and convincing. The state would have to show that it's highly probable or reasonably certain that these things happened. We're even below that. We're at a preponderance of the evidence. All the state has to show in a dependency case is that it's more likely than not that the allegations are true. That's not a hard burden for the state to meet. And by the time they remove kids, they have the evidence. Sometimes you guys will get a report and it'll have report after report after report that's been investigated, unsubstantiated, investigated, substantiated, services put in place. It's like, why didn't they remove the kids 6 reports ago? But most of the cases you get, unless something is really egregious, they work with the families and try to do services without court involvement before getting the court involved. So say, though, that now you're involved with the court, you have to make a plea. You can go in. Parents have a constitutional right to trial. They have a right to parent their children. They can go in and say, Judge, I admit these allegations. I admit the allegations. And the judge will say, okay, I'm finding your children dependent, meaning your child doesn't have a parent who's willing and able to safely and effectively parent at this time. So you have a dependency, and we're off with the process. And that's about the time a CASA would be appointed. You can say, Judge, I absolutely deny these allegations, and I want a trial. Okay, so the judge is going to set you for trial, pre-trial conference. Trial has to be held within 90 days of service of the petition. Now the state's going to come in, DCS, and they think they had enough evidence to file the petition. Now a couple months have gone by, and this whole time they're gathering more evidence. And so they're going to put on witnesses to testify about drug abuse, police reports, the DCS case manager and investigator will testify. The court will get all these documents, positive drug tests, positive hair tests. We see a lot of positive hair tests on kids that are exposed to meth. The judge is going to see all of that. And the judge is going to say, you only have to prove it by a preponderance of the evidence. And so I'm finding that these kids are dependent. Okay, so now we're off on the dependency process. The third option, and what I always told my clients, almost always to do, is deny and submit, where you go in and you say, Judge, I deny these allegations. They're not accurate. But I'm going to let you decide, Judge, just based on the one DCS report and the DCS petition, just on those two things. I'm going to let you decide. And the judge will say, 99% of the time, I find these kids dependent. So whichever way you go, you end up with a dependency. I always told my clients to deny and submit, especially if there were criminal involvement going on, because you didn't want them admitting to something in this case that could be used against them in the criminal case. But any of those ways, we end up with a dependency, and we end up in the dependency process. It's not unheard of for the state to lose a dependency trial, but it's pretty rare because of the low burden of proof and because they have already gathered so much evidence by the time they remove the children. The trials in a dependency and severance case are bench trials. When I first started practicing law in Pima County, the state of Arizona decided, we think the parents should have the right to a jury trial because we don't think that they're getting a fair shake from a bench trial. So we had jury trials for 2 years, and they kept the statistics to see, did this affect the outcome for these parents? Were they more likely to get their kids back if they were entitled to a jury trial? And I remember I was a baby lawyer, and it was my first jury trial, and Mom, there were 3 kids. She was the poster child for meth. She did not one thing. She did not one thing to get her kids back. And by God, she wanted a jury trial. And we went in, and we had a really hard time choosing a jury because everybody hated then CPS. Nobody wanted to touch it. But by the time those jury/taxpayers heard what DCS tried to do to reunify that mom with their kids, they severed her on 3 grounds in 20 minutes. So the jury trials did not last. So we have the bench trial, and the goal in our cases is one family, one judge, which is a hard thing for parents to swallow because if the judge is on at the beginning of the case and sees you at your worst when you've lost your kids, and now sees you through 12, 15 months of the reunification process, and now that's the same judge is going to decide whether your rights are terminated. There have been more than one trial in the Court of Appeals that was unconstitutional, but it has been held up as constitutional. So we have the one family, one judge. Okay, so I already covered all of that. The court enters orders for custody, placement, visitation, and services, and the process is started. Privacy and confidentiality are a huge issue in our cases. In a juvenile delinquency case, even though they're juveniles, those cases are not closed. You can go in and they're available to the public. Not so with the dependency case. If you went to the clerk of the court and the juvenile court and said, I want to look at this file, you're not going to get it. You can go to the family court and read about your neighbor's divorce or custody battle or, things are open to the public. But the juvenile dependency proceedings, the juvenile files are closed. You cannot get them. Obviously, as a CASA, you're going to get those files, and confidentiality is very important. You don't get to share those with anybody. The hearings themselves are open. They used to be closed to the public, and I think it was in 2004 they opened them. So they are open to the public, but they can be closed for good cause shown. And the judge, before every single hearing, should be admonishing everybody in the courtroom that their proceedings are confidential and that the judge doesn't want anything about this case posted on social media, doesn't want you out to dinner talking about the case or anything that happened in that courtroom. You are under the jurisdiction of the court, and you can be found in contempt if you find out that you're breaching confidentiality. But you can, as I said, you can have it closed for good cause shown. CASAs a lot of times don't like the idea of the kids coming to court. And foster placements a lot of times don't like that. Kids do have a right to be in court with their counsel. And when I was representing kids, if they wanted to be there, it's their life, I'd make sure that they were there. That was a juggling thing. Do you want them missing school more? They've probably already been missing school. But just know that they do have a right to be there. But the judge can say, okay, let's hear from Janie first, and how's it going, and what's going on at school, and how do you think things are going, and then we want you to step out into the lobby while we finish the hearing, and then if there are things that the judge thinks that's not in the child's best interest, remember the juvenile court, the paramount consideration is the child's health and safety. And so the court can close part of the hearing. I had a case where I represented a dad, and he found out that he had a baby on the internet, and he hit the ground running trying to get this kid, and she had already been put in adoptive placement, and they wanted to fight. And he did his case plan, and they would show up at every hearing trying to figure out what was going on with dad because they wanted his kid. And so I asked at the beginning of every hearing to have it closed to protect my client's privacy rights. And the judges are, I think, pretty open about closing the hearings. They consider whether it would endanger the child's physical or emotional well-being to have it open. They consider whether an open hearing would cause material harm to a criminal investigation. And then, like I said, they consider the privacy rights of the parents and of the child. A contested temporary custody hearing, if at the very beginning of the case, before dependency is even found, the parent just wants to say, okay, I'm not going to fight the dependency, but I think the kids can be placed with me, they can ask for a hearing on that. The burden of proof for that is probable cause, which is nothing for the state. And so those don't happen very often, but the parents certainly have a right to that at the beginning of the case. If a case is set for trial, for a dependency trial, we'll talk about severance trials in a minute. If they're set for a dependency trial, the court will schedule a mediation. And that'll be held 4 to 5 weeks after the PP5 hearing. Mediation, obviously there's no judge. It's very confidential. The mediator cannot be subpoenaed. Nothing you say in that mediation can be used. Say you end up going to trial and somebody tries to say, well, so-and-so said in the mediation. No, the judge will strike that. Everything is confidential because we want people to feel free to talk and try to resolve the issues. The parties only are included. Placement is not included. Grandma's not included. The only non-party that is included is the CASA. And you guys absolutely have a right to be at the mediations. Just know, again, that they're very confidential. There are different kinds of mediations. If the parents are contesting the dependency petition and they want a dependency trial, you're going to have a dependency mediation. If you're going along in the case and somebody thinks, I don't think the parents understand what they're supposed to be doing, then you might set a progress mediation where you all go in together and talk about where are we in the case and what progress is being made. And then, as we'll talk about in a little bit, if a motion to terminate parental rights is filed, then you can have a severance mediation. Lot of cases are solved in mediation, especially at the dependency level. So they set a mediation, and then they set a pretrial conference where you go in and say, we either are affirming the trial date or we're not going to contest the dependency. That's the pretrial conference. And then we also have, the day of trial. If a parent doesn't show up for one of those hearings, the court can proceed in their absence. They're all represented by counsel, usually. Very seldom a parent will be found not indigent, and then it's up to them to get their own lawyer. But usually they're all represented by counsel, their lawyers will be there, and if they're not there, and they can't show good cause, like they were in the back of an ambulance, the court will go ahead and make decisions about those children in the parent's absence. And the parents are warned in writing and should be at every court hearing that their failure to appear will be an admission to the allegations and the children will be found dependent. I think Jenny talked a lot about visitation of services. That's more a DCS thing. But like I said, we have the visitation starts out supervised. Sometimes it's therapeutic. And then as the case goes along, okay, mom and dad are doing really good. Now we're going to move to unsupervised visits. Those are going well. Now we're going to move to overnight visits. That's going well. Now we're going to move to an in-home with court oversight. So we always start out with visitation orders, services for the parents and the children, and like it said, it has to be reasonable to facilitate the case plan. If the case plan is reunification, which in most of your cases, even if you think it should be otherwise from the beginning, DCS has an obligation to try to reunify the family. And so if mom has a substance abuse problem, then we have to have services reasonable to facilitate the case plan and her substance abuse issues. So a substance abuse assessment, random drug testing, substance abuse treatment, inpatient treatment, whatever they decide the mom needs to overcome this hurdle. So say there's a mental health allegation for dad, then he's probably going to be ordered to do a psychological evaluation to find out, okay, where are his parenting weaknesses and strengths, and is he able to parent the children? There's a wide variety of services, parenting classes, drug testing, hair follicle tests, mental health services, the parent aides for the supervised visits. We also have parent coaching in some counties, which is more hands-on during the visits, teaching the parents how to parent their children. So once we have the judge finding that the children are dependent and we're in the dependency process, now we start the report and review hearings. By law, they're supposed to be held every 6 months. But you'll see on that county sheet that Sue gave you, that varies in the counties. A lot of judges hear them, I don't think Maricopa, but a lot of the other counties will hear the case every 3 months. And that's really important when you have a child under 3, because of the 6-month timeline is a big timeline in the law. If they're not hearing the case every 3 months, those parents are only going to be in front of that judge one time, and there could be a motion to terminate their rights. So hopefully the judges are reviewing them more often, but it is only every 6 months. There's a right of participation by the placement, the relatives, and the care providers. So all of those people should be at the hearing, at these review hearings, let the judge know what is going on the case. The placement has a right to participate, but the placement is not a party to the case unless they move to intervene. So if somebody wants it closed and wants the placement out, that could happen. It says here, I should take this out, the hearings may be contested or uncontested. The review hearings are generally uncontested. If there's a contested issue like, I had one a couple weeks ago, mom wanted unsupervised visits and the guardian ad litem for the kids said no. So it was set for an evidentiary hearing and witnesses were called and exhibits were entered just on the issue of visitation. But usually at a review hearing you won't be entering evidence or calling witnesses. You just have the DCS report to the judge saying this is what's going on in the case, have the CASA report to the judge, this is what's going on in the case, and the FCRB, Foster Care Review Board report, they review the case every 6 months and they also send a report to the judge. So sometimes in the beginning it's hard for CASAs to wrap their head around, well, do I need to put that in my report? The judge probably already knows that. No, all the judge is getting are those 3 things I just told you. So the judge isn't getting the psychological evaluations or the drug tests unless they're admitted in evidence at a trial or an evidentiary hearing. So it's up to you to say, I've reviewed the documents, I reviewed the psych eval, this is what the psychologist recommended, these are my concerns. These are the results of mom's drug tests over the last 3 months. These are my concerns. And sometimes CASAs will say, well, DCS is going to report that anyhow. You don't want to rely on what DCS is reporting because, frankly, they are completely overworked. They make mistakes too. And you might have a different perspective. So you get to review all of those documents and make sure that you're including that in your report. Federal funding is tied to reasonable efforts. The judge has to make a reasonable efforts finding throughout the dependency case, at least once every 6 months, but a lot of judges just routinely do them at the review hearings, saying DCS is making reasonable efforts to achieve the case plan. So most of your cases, in your report, there's one small little section, reasonable efforts, and you'll just say, I believe DCS is making reasonable efforts to achieve the case plan of reunification. Or if the case has progressed, I believe DCS has made reasonable efforts to achieve the case plan of severance and adoption. It's just a 1-sentence thing. But DCS has to make reasonable efforts. The judge has to make that finding. If they get audited and it's not being found, they'll lose federal funding. Or if they get audited and it's found that no reasonable efforts findings are made, then unfortunately, I think that the children end up getting dinged for it because DCS loses funding. So it's not, even though it's a 1-sentence thing for you guys in your report, it's not a trivial thing. It's a big deal. I mean, are reasonable efforts being made? And like Jenny said, that doesn't mean, did I hold mom's hand every day and make sure she got to her drug testing? I mean, they have to do their part too. But they have to make sure the services are set up. Because when you think about it, at that very first hearing, you've got parents who, most of the time, either substance abuse or mental illness. They're angry because their kids have been removed. They don't understand the system. That whole PP5 conference is just a blur to them. So we have to make sure that DCS has everything in place for them, that they know what they need to do. But ultimately, it's up to them to do it. Yes?
When you say federal funding is tied to these findings, do you mean federal funding for DCS or federal funding for the services that are going to be allocated to the case?
For DCS.
So that's why they keep trying to reunify and give so many chances?
No, they try to reunify and give so many chances because that's what the law says. You have to have a ground to terminate, and we'll talk about that again in a minute. But no, the case plan starts at reunification because legally, and even if we start a case out and you do have a ground for severance, generally DCS won't do that. They want to give the child a chance with the family. Other contested hearings. Mental health hearings. If a kiddo is placed in a locked residential treatment center or a psychiatric hospital, that case has to be reviewed every 60 days because even though they're minors, they have constitutional rights and they have a right to their freedom. And so the judge has to review it every 60 days. There has to be a doctor's finding that hospitalization continues to be necessary, and the judge has to make the finding that that is the least restrictive placement consistent with the needs of the child. So we do have a lot of our kids, unfortunately, do cycle through the residential treatment centers or the psych hospitals. And like I said, those had to be reviewed every 60 days. Visitation hearings I already talked about. If you think that you should be having unsupervised visits or overnights and either DCS or the child's guardian ad litem is against that, that can be a contested hearing. Placement hearing, at any time during a dependency, the parents can petition the court for placement of their children. The burden is on the parents to show that return of the child wouldn't create a substantive risk of harm to the child's physical, mental, or emotional health or safety. I'm not sure about Maricopa County. I think I've practiced in 12 counties in the state, and Maricopa is not one of them. But placement hearings don't happen all that often. But when they do, if the parents can show that, then we move to what I've already talked about, the in-home dependency, where they get their physical custody back, but the kids are still in the legal custody of the state. Permanency hearings. This is also mandated by federal law. If the children are over 3, a permanency hearing has to be held every 12 months. If the child is under 3, permanency hearing has to be held at 6 months. And what happens at the permanency hearing is it's kind of like a review hearing on steroids. It's like, okay, I'm looking at the DCS report, I'm looking at the CASAS report, I'm looking at FCRB, and DCS, what is your recommendation? Well, we think mom is doing really well. She's not quite ready to have the kids back. We think she should have more time. And the court can say, okay, I'm going to give mom more time to reunify with the kids. The court can say, DCS can say, or the child's attorney can say, I think that the case plan should be changed to severance and adoption. If that happens, then and the court agrees with it, then the case plan is changed and an initial severance hearing is set. We can have a recommendation that the case go to guardianship. And I told you about the Title 14 guardianship that you can undo at any time. In a Title 8 guardianship in the juvenile court, if the case plan is changed to guardianship, that guardian gets all of the legal rights to the child, but parental rights aren't terminated. So that if down the road mom does get her act together, she can petition the court to get the kids back. But unlike a Title 14 where you can just go down and revoke it, you actually have to file a petition and convince the judge that your circumstances have significantly changed and that you can now parent. Don't like to see guardianships, even though they're permanent guardianships, is what we call them in the juvenile court. They're still sort of tied to the system then until they turn 18. And so especially for the young kids, we don't usually do that. But kids who are over 12 have to consent to their own adoption. So if you have a kid over 12 and they don't want to be adopted, we don't want to just be in the business of making legal orphans and terminating rights and having this kid that is not going to consent to adoption, and so now what? So if there's a fit guardian, then sometimes we'll do guardianship. And the other option is for the older kids, especially the ones who say they don't want to be adopted, there's no potential guardian, we have the APLA, alternate plan permanent living arrangement. It's kind of the long-term foster care or group home road where they stay in the system until they turn 18. But the judge has to, at the 6-month mark for under 3, at the 12-month mark for over 3, the judge has to make a finding of what the permanent plan is for the child. If the court approves TPR, termination of parental rights, case plan, didn't just terminate your rights, she just approved the case plan change to severance and adoption, she'll order DCS to file a petition terminating parental rights within 10 days. And then she'll set an initial severance hearing 30 days out. To terminate parental rights, there are 11 different grounds to terminate parental rights. For example, abuse and neglect, abandonment, incarceration, either because the length of time is going to take up a huge chunk of the kid's life where the parent's not able to parent, or incarceration because of a heinous crime like you murder. It has to be something truly heinous, like you murdered the mother in front of the children, or sex abuse, mental illness, substance abuse, and then we have the time and care grounds where, say you have a child under 3 and the case plan has been going for 6 months and the parents aren't doing anything, they can move to terminate rights, just saying, okay, the kids have been in care for 6 months, parents aren't doing anything, doesn't look like they're going to do anything. We've made reasonable efforts, we've had that finding, and so we're going to terminate on that ground. For kids over 3, it's 9 months. If you get to 9 months and the parents aren't doing anything, or very little, it doesn't have to be nothing, they can move to terminate on the 9-month ground. The ground that drags cases out and that we see a lot is the 15-month ground where the language changes. So at 6 months or 9 months, the state has to show that mom or dad substantially neglected or willfully refused to remedy the circumstances that caused the kids to come into care. The 15-month ground, you have to show that the parents had been unable to remedy the circumstances. And those are tough cases because you can have a parent who's jumped through all the hoops, done everything they've been asked to do, but they still can't parent. So the case kind of gets dragged out to the 15-month mark, and then that's another ground for termination. You only need one ground to terminate, but when I was supervising attorneys, I always told them, don't file a suicide petition with one ground, because if you end up in the Court of Appeals and that ground is reversed, we're back to square one, basically. So you want to have more than one ground, so the Court of Appeals say, well, we agree that the trial court shouldn't have found that ground, but this ground is strong, and so we're going to go ahead with and affirm the termination. Once that motion for termination is filed, then we're kind of back to how I described the dependency. You can either do a no contest, and the court terminates your rights, or you can say, I want a trial. And if you want a trial, then again, it gets set for mediation, pretrial conference, and trial. The burden of proof in a severance trial goes up a little bit, but it's still only clear and convincing evidence that the state has to prove. And like I said, usually by that time, they have, now you've had a parent, all the drug tests, the psych evals, all of this evidence to support your grounds. It's not unheard of the state to lose a severance trial, but they win most of them. And when they go to the Court of Appeals really tries to affirm the trial court's decision, but they do reverse and remand once in a while. And when that happens, then, the judge doesn't just say, okay, the termination has been reversed, here are your kids. No, we're back to, okay, now what are we going to do? More reunification services, more time for the kids in care. So you have to show one ground. You also have to show that it's in the child's best interest. And that's generally not hard to do. Pretty much all you have to show is that the child is adoptable. And hopefully if you're at termination, your child is in an adoptive placement, and that's all you have to say is the child is adoptable, and termination of parental rights will free the child for adoption, and that's a benefit to the child. And it would be a detriment to the child because, mom is still using drugs or dad is incarcerated. So you have to prove one ground and best interests. Once the termination happens, during this whole process, if DCS was ordered to provide services, even if excuse me, even if you've gone through a dependency trial and a severance trial, during that whole time, they have to provide services. Even if the case plan has been changed to severance, unless the court has relieved them from providing services, they have to keep providing services. So the time, if the motion for termination is granted, then they're relieved of providing those services. Visitation stops. A lot of times there's a therapeutic goodbye visit. And that's really hard for parents if they say they want to appeal and they think they're going to win the appeal. They want visitation and services to continue. But once that termination happens, those things stop. The parents have a right to appeal the termination. Within 15 days of the termination, they have to file a notice with the Court of Appeals. And like I said, the Court of Appeals, Division 1 in Phoenix, even though juvenile cases trump, it takes a good 4 to 6 months to get through an appeal. Legally, DCS could go ahead with the adoption pending the appeal, as long as the adoptive parents in their petition say that they're aware that the case is on appeal and they want to go ahead with the adoption. Technically, legally, they can do that, but nobody wants to do that because they're afraid, okay, what happens if we go through with the adoption and then they reverse the case and the parents are back in the picture? I mean, what does that do to the kids? So they can go to the Court of Appeals. Like I said, that's going to set your case out another 4 to 6 months. And then if the Court of Appeals affirms the trial court, they can petition the Arizona Supreme Court to review the case. So that doesn't happen all that often, but it does once in a while. They don't take them very often. They don't take all the cases. They just review the petitions and decide if they're going to hear it or not, and that could be the end of it. I had a case where I was GAL for 2 very small girls. One of them had been in the foster home since birth, and Dad actually petitioned the United States Supreme Court. He went up the Arizona ladder and got turned down. So he petitioned the United States Supreme Court. That's the only one I've seen going that far, but they didn't touch it.
At this point, how much time has typically lapsed since the PPC? Is there a range where you're at PPC determination of parental rights?
Well, like I said, if the parents are not doing much, you can see the termination at 6 months or 9 months. Or if the parents just disappeared, you can see a termination at 6 months. But generally, in my experience, the cases go on 12 to 15 months. And then say you get to the 15-month mark, and DCS could still say they want to give the parent more time. I cited on a case this morning, the mom has been 2.5 years, and we're still trying to reunify. Don't get me started. So it really depends, but I would say generally 15 months to 2 years.
I'm wondering, okay, how much of this should, as a guardian ad litem, should you understand? For example, I'm completing a master's in conflict resolution, and I'm listening to this with a little more awareness of what you're saying, which doesn't mean you're an expert in any direction. But as a guardian ad litem, how apropos, how important would you say this was? Knowing these things, I mean, in terms of the person.
How important would I say what was?
This knowledge, knowing what you're telling us today.
How important that is to a CASA?
Yes.
To try to help you understand why the cases proceed the way they do. Because a lot of times, like I said, you look at that initial report, and there have been 10 reports on the family, and the case plan is reunification. Why? Or say we're 4 months into the case, and the parents aren't doing anything. Why can't you change the case plan to severance? Because you have to have a ground to terminate. So we just want to make you understand, first of all, these cases do go on for quite a while. Want you to know how often you're in front of the judge, how often the judge is reviewing the case, and how important it is for you guys to have your report to the judge, because the judge is getting limited information on what's going on. Yes, what we're telling you is the system is definitely not perfect, neither is the law, but it's what we have to work with. And as CASAs, it's not your job to change either of those things. It's your job to work within the system and advocate the best interest of the child. So I believe that judges really do, obviously the older the child gets. So a 10-year-old, you're right on that line. Does the judge take that child's wishes into consideration? I think absolutely, I do. Are they going to have him adopted by somebody they don't know? No. By the time, and that's where you have to be careful. Like, okay, I want to terminate rights. Okay, are the kids in an adoptive placement? Do we have a plan? We don't want to, like I said, we don't want to just be creating legal orphans. So hopefully by the time, if your case, say your kiddos are in a foster adoptive placement, parents are working services, things aren't going well, the kids are bonding with these foster parents, we know from the beginning they want to adopt, then hopefully by the time we get to termination, that 10-year-old is going to be bonded to these people and is not going to have a problem with it. But legally, you have to have a signed, notarized consent from a child over 12 saying that they consent to the adoption. And you don't have to have that if they're under 12. We already talked a little bit about APLA. They don't like to call it long-term foster care, but that's what it is. Unfortunately, we're seeing a lot of kids. We don't have group homes in Yavapai County, but we have a lot of our kids placed in group homes in Phoenix, and a lot of them are aging out in the group home system. There is a YAP unit, the Young Adult Program. It's a special section of DCS for young adults. At 16, they're eligible for skills training, and at 17, they're eligible for subsidy. And I think it's a great thing that the subsidy is available until they're 21. When they turn 18, if they turn 18 during a dependency, the dependency is dismissed. The court no longer has jurisdiction. But if the kid decides to voluntarily, the kiddo can stay in the DCS system and get insurance and subsidy and help. Unfortunately, a lot of the kids, by the time they're 18, want everybody to go away. They don't want to be in the system. But that is something they should be working with them before they turn 18 and let them know what their options are. One of the things on the relative placement, I don't know what that is, is. Relative placement, DCS does try to place with relatives, and that's good for the children. A lot of times the relatives are a problem too, but they do start out looking at relatives. One of the things I always ask my CASAs to bird dog is, you get a case, the kids are placed with the grandparents, kids are bonding with grandparents, everything's going great. Nobody ever did a home study. Even though they're relatives, a home study has to be done. Criminal background checks have to be done on all the adults in the house. They have to be fingerprinted. House has to be checked out. That all has to be written in a home study and approving placement. What I've been seeing happening is we get to termination. The kids have been placed with grandpa and grandma. Now we want grandpa and grandma to adopt. We didn't know that grandpa was a registered sex offender. Now we got to get the kids out of that house. And so that I do think that's a really important CASA job, is when you first get that file, look and see if there's a home study, even if it's a relative. If it's a DCS licensed foster care, obviously you're not going to have that. They're licensed, but not that they don't have issues. But if it's grandparents or the aunt and uncle, even though they're relatives, you need to be looking to make sure that that home study is there so that we don't have a big surprise when we get to termination. Well, they don't have to get certified. A lot of times DCS will ask them to get certified because then they get help financially, which if you're just grandma, you really don't. You get some small, it's not like being foster licensed. So they don't have to go through the foster licensing system. As far as the home study, DCS should be getting that done, I would say within a month of the placement, so that you know, because you don't want to, obviously you don't want to leave the kids there if they're unsafe, and you don't want to leave them there so they can start bonding with these people and find out we have to remove down the road.
I don't know if it's a legal question or not, but if you're working with a kid that is turn 18 and they're doing well in school, is the law that once they're 18 they're out, or if they're in school, or can us as CASAs advocate for them at all?
After they turn 18?
Yep.
No.
Okay.
You know, if you want to stay in touch, if say you're a CASA for teenagers, and I see this a lot, and you want to continue having a relationship with that kiddo after they turn 18 and they're out of the system, then that's absolutely up to you. I mean, you can have just a regular friendship, but you're not the CASA anymore. I had a CASA yesterday say, I heard, that it's a case that's been dismissed, and she said, oh, former foster dad, kids were returned to mom. Former foster dad called and said that the kids came to daycare dirty, and I'm like, you're not the CASA anymore. if the case isn't before the court, as hard as that is to hear, unless you think there's abuse and neglect going on that you need to call the hotline for, you're off the case. The other thing you have to be careful about is, say you're bonded with your teenage CASA kid and he turns 18 and he wants to go get a job. You have to be real careful about letting them use you as a reference, because you can't say, well, I was his CASA, because that's confidential. We don't, oh, he had a CASA, he was in the court system, well, what's up with that? So you have to be careful, but no, 18, and that, truthfully, that is something that really bothers me, is these kids turn 18 and we all go away, and then what happens to them? So, anything else? Yes.
Well, we just talked about kids aging out of the system at 18. However, if they're in a young adult program, at 18 they can get subsidies to continue on in certain training. It seems like there's conflicting statements
So
there.
what happens when they turn 18 is the juvenile court no longer has jurisdiction and there's no dependency. But outside of the court system, outside of CASA, and those DCS case managers, they can still be part of DCS services through the YAP unit until they're 21. But there's no court oversight or no CASAs on the case or no reports to the court. It's just a voluntary thing that they can have until they're 21.
There was a statistic shared earlier that 90% of the kids in foster care don't get a CASA. Who decides which foster child gets a CASA and which doesn't? Do you know?
So I know Sue told me not to do this, but I can only speak to Yavapai County. Our judge orders a CASA appointed on every single case, because that's always the goal. The problem is we don't have enough CASAs to go around, obviously. So what happens is, say you go through your certification and you're swearing in and everything, and now you're ready to get your first case. You meet with your coordinator, talk about what kind of kiddos you want, sibling groups, age, issues, whatever. And your coordinator will pull several cases for you based on his or her experience of which case, sometimes you see a case and you go, oh, this case, I mean, it would be great if they all had CASAs. But you have a particular case, oh, this case really needs a CASA on it. That case I just told you about that's been open for 2.5 years, we just got a CASA on it last month. And the reason we were in court this morning was because of the CASA, because she went out there and started digging up on what's been going on. So, I just lost my train of thought. What was your question? Oh, who decides? You and your coordinator. I mean, the coordinators decide which cases need a CASA most, and will match you to what you think you want to do, and then you meet and you choose a case.
And if I can say, all of the dependency cases go to all of the county offices, as Penny said, and the coordinator, the person that leads that county, it could be the county coordinator if it's a smaller one, or the program manager, and the coordinators get together and they determine the priority of which children get a CASA.
Okay, anything else?
I'm confused about something.
Yes.
So, after they've gone through this whole process, it takes a while, all the services, etc., and then they land in TPR and parental rights are revoked, but the foster home is not able to adopt them, then these children, where do they go?
You have to keep doing relative searches. You have to do what we call red file staffings and find adoptive placements that are potentially interested and try to match them to the kids.
So are those the Heart Gallery? Is that why they end up in there?
End up in where?
In the Heart Gallery. It seems from the Heart Galleries, the Wednesday children, where they're advocating for them to be adopted, that they're older children.
Right.
And, it's taken a while following the process from a legality standpoint, and all the parties are involved. So I was wondering, and you mentioned that you don't want to create legal orphans, so I was just wondering, how did they end up?
It happens.
gallery?
I mean, it happens that you terminate parental rights and they disrupt out of the placement for whatever reason. Now, okay, the parents are gone. So I'll tell you one more war story and then I'll stop, I promise. I had a case in Pima County. Mom had a huge meth problem and she had her rights terminated to 2 kids. They were older. So their rights were terminated, and so she thought they went off and got adopted and lived happily ever after. She had another baby. She came under the radar of the system because of her prior severances. So DCS filed on the baby, and we went to court on the baby, and Mom walks into the juvenile court in Pima County, and there's her teenage kids. She's like, what are you doing here? They were never adopted. So there's no mechanism in the law for you to adopt your own children. So we did a guardianship, and she got guardianship of her own kids. And there is a proposed bill right now in exactly those situations where you've got kids and now all of a sudden you don't have a placement. If time has passed, DCS, if it goes through, they'll be obligated to look at the parents and see has their circumstance changed and can they parent these kids now. So those are the tough ones. All right, well, thank you.